Excellent. Welcome, everyone. I'd like to open the November 25th, 2025 Bethel Planning and Zoning Commission meeting. Start with pledge of allegiance. Pledge of allegiance
to the flag of the United States of America, to the republic which stands one nation
under God, indivisible.
liberty and justice for all.
Thank you. Let's do a roll call and we will start on mine. Mr. Legnard.
Bob Legnard, Commissioner.
Adam Person, Commissioner.
Jeff DeRosa, alternate. Mike Grabowski, Vice Chairman.
Paul Shanley, Chairman.
Kitty Grant, Secretary. Diane Ryan, Commissioner.
Squirrel Braden, Commissioner. Dan Carter, First Selectman, ex-officio member.
And staff with us this evening.
Jeremy DeCarly, Interim Town Planner.
Amanda Martinez, Recording Secretary.
All right, thank you. Looks like we have a full house of full members. So good morning, Jeff. Thanks for watching. Seated for this one. We're gonna roll right into a new public hearing for Bethel Planning and Zoning. The commission initiated amendment, text amendment requirements when the commission initiates a zone change. Jeff, read that public notice.
To appear November 14th, 2025 and November 21st, 2025, public notice. The Bethel Planning and Zoning Commission will hold a public hearing on November 25th, 2025 in Meeting Room D of the Municipal Center, 1 School Street, Bethel, Connecticut at 7 p.m. to hear the following. Text amendment. Revisions, section 8.7.b. Submission requirements and section 8.7.c proceedings. A link to review the materials can be found on the town's website. The public may send comments via regular email and email to the land use at bethelconnecticut.gov. Parking for hearing is located to the rear of the building. Paul Shanley, Chairman.
Thank you very much. Jeremy, do you mind giving us a quick rundown of what exactly you're looking to do?
Sure.
Thank
So as you all will recall, back when we initiated a process to make some amendments to the TOD, we discovered that there was a couple of sections in the zoning regulations that require that any maps filed in support of a zone change require the signature of a licensed land surveyor. Simply is impractical when the commission is trying to make large scale zone changes. Anything more than a lot or a couple of lots, it's cost prohibitive. You don't have access to those properties to do the surveying. The regulation is a little bit vague in terms of level of survey. It doesn't specify A2, T2, or any other level of survey. It just simply says map signed by a licensed land surveyor. And I would suspect that a licensed land surveyor is not going to be too keen on the idea of signing a map, which is based on the assessor's map created within the office. So like many other towns across the state, we're implementing, or we are proposing to implement some language which allows the commission relief from that requirement when you initiate a zone change. In lieu of a licensed land surveyed map, we've put together language which requires you to structure a map based on the town's assessor's map, and then include a list of properties within that proposed zone change, as well as a list of properties within 500 feet surrounding that zone change. And there's a couple of reasons statutorily for that. There's a petition process by which anyone within that 500-foot radius can sign a petition. 20% of those folks, if they sign it, gets into a supermajority. I won't go too much deeper than that, but there's reason for that. So that's kind of the rundown of it. I can read the amended regulation if you'd like. I think you have it in front of you this evening. But that's just quick and dirty. Yeah.
Okay. Does anybody want to get into, any of the commission members want to read the whole thing aloud?
No.
Or everybody have a chance to review it, or I know the gist of what we're doing here?
Right.
One real quick question. You say other towns, how, like, in the surrounding area throughout the state of Connecticut, other towns?
But
most towns have adopted something like this.
Yeah, and I will say too that the language has been run through Chuck and Andrews.
Thank you.
Thank you. I will, before I open up to public comment, has everyone in the room signed up that wants to speak on this public hearing? I see there's a couple names on here. Is anyone online, joining us online, that want to chime in on this? This is the zone change. I would add you to the list. I don't see anybody. I will check again. The first name I have on the list is Nancy Sudik. Nancy, can I just have your address, please?
2 Ridgedale Road.
Can I stand here? Like, can they see me if I stand here?
No.
You're gonna have to come up front there.
Front, please.
Okay. Oh, I see. Right, okay. Okay, I see. Okay, so anything that Jeremy just said, totally agree with. I totally understand it. My question is the proposal to not notify neighbors by mail in the event of a P and Z, in the event of a P and Z initiating a zone change in a Bethel neighborhood. Not everyone can be involved in the affairs of the town. And I believe that something as important as a potential zone change should be communicated to abutting neighbors through the mail. And I know it's expensive, but I just think it's important to do it that way. Promoting transparency and open communication has always been a hallmark and a mantra of this commission as long as I've been coming to meetings. And I would ask you that you not take any steps that would diminish the current transparency and open communication that we all enjoy that we have. So that's my suggestion. Thank you.
Excellent. Thank you, Nancy.
You're welcome.
Mr. Chair, if I can respond to
Yeah,
that really quickly.
sure.
When the commission initiates an application for zone change, notification is already not required. I am not proposing that at this time because it's already in the regulations. It has been for a number of years. I don't have that section in front of me. I can pull it up, but
Okay.
it's already not required.
Gotcha. Thank you.
So to clarify, we're not changing it, that it's not required. It's already on the books.
Correct. That is already there. Yep.
So then Nancy's question is asking us to add it.
Well, it
I
is
saw.
now. We didn't intend it to be that way. I didn't know that part.
So we need to add it.
You don't need to. There is a carve out in state statute which allows you to not send a butter notification.
But
when
we
you-
can.
But you can, sure.
Right,
But
okay,
it's not required.
okay.
But
Gotcha.
may I ask you one question? But we always have. And then with this commission, we've always done that.
I can't speak to that.
Well, I
It's-
can. For
it's-
32 years, I can.
Well-
We have always did not done that notification. So now we're not doing it. Okay.
never
Well, it was
Never
never
required.
required.
Well, it was required, but we always did it. That's the point. I think for neighbors, I think that it's a very good thing to let neighbors know what's exactly going on right next door to them.
Before we
That's
get,
just,
I mean, that would be a
Mr. Chairman.
substantial cost, wouldn't it?
For clarification, it's my understanding we haven't done that for some period of time. It's certainly voluntary to the board if you want to, based on a certain, what you're doing, but in many instances, you guys haven't sent them out. My understanding.
well, before we get into that, let's, I have Mr. Brad Colts is the only other person that signed up, so let's let him have his public comment and we'll have our discussion.
Brad
Sure.
Holtz, One Fairchild Drive. I had a question, also about notification. I've followed the discussion as closely as I could, but I confess I'm slightly confused. Are we saying that abutters don't need to be notified, but those within a modified zone do? Or do those within a zone that's being changed also not need to be notified? And if so, is that by mail? And my point would be, again, to encourage transparency. I would encourage the commission, if it's not required, make it required, certainly for property owners within the boundary of the zone change. It was my understanding that was a requirement. But if it's not, I would ask that you make it that. And if it is, I would ask them to not remove it. Thank you.
Thank you.
Thank you. All right, anyone on, last call, anyone online? Before I turn it over to commissioners? No one? Mr. Leitner, do you have anything?
No, I'm okay with it.
Kenny?
As long as we remember to actually do it. I mean, I like the idea of people knowing what's happening on the property. I'm also okay with changing it so we have to do it. I just feel really bad if we made a change and we didn't tell him.
No comments.
I'm with Ken, on that. I mean, ostensibly, you're changing the value of someone's property potentially, good or bad. And, you know, there's financial risk to that, and I understand this could be costly, and there could be a good amount of people that have to be notified if we make it part of our regulations, but I mean, we're not doing these every meeting, zone changes, special circumstances usually, so I'd be in favor for something in there that would require public notices specifically to people whose property is getting changed. That's my 2 cents.
Okay. I will usually save my comments to the end, but I will jump in. I support the proposed change as far as removing the requirement for a signed map by a licensed surveyor. That's the real reason we're all here discussing that. The notification thing that Nancy brought to our attention is, I think, a no-brainer. I think, I mean, it's something we can add in while we're changing it, right?
No, it would need to be a separate
There'd be a
application.
separate application.
Yeah, because this application pertained to section 87B and 87C, and that's what was noticed, and that was put on the legal notice. A revision to that would be 8.10 G.
Okay.
So we can continue with this,
Alright, so-
render a decision and then do a separate.
You could, yeah,
So we'd have, and then trigger another public hearing again.
change that language. Yeah.
Well, well, for the fact remains, I support, our proposed change as written, and I will support, a public noticing, change in the future as well.
I agree with what was written, what the original idea was for this meeting. But I also think that it's very important at a later date that when this commission meets again, that I was never aware that you were not notified the way we always did for decades. And I think it's very important for a person to know what's going on around their property. And I think it's important that you look at it again, and if you don't have it, to reinstate it, if possible.
So just to clarify on that too, I just want to make sure everybody understands. If a private citizen submits an application for zoning, the notification requirement stands. So they have to notify the neighbors and those that are within it. It's just an exemption for the commission, and that was done as part of Public Act 0608, I think. So that's 2006. So it was back in 19 years ago that the statute changed to allow you to carve out that exemption for those commission initiated applications. I don't know when the town enacted it, probably somewhere around that time would be my guess, because of the cost of notification. I mean,
Oh,
talk
just the
about a large-
commission initiated.
Just the
I'm
commission.
sorry, I
initiated,
wasn't
correct.
aware of that. I thought you meant for all
No,
zone changes.
no,
Oh,
no.
well, then-
Notification requirements are there anytime there's an application
Right.
from the public. It's just
Right, exactly.
commission initiated ones
Oh,
that have that exemption.
then I'm okay.
So you think it was a cost initiative?
I mean, I think it's also probably to some extent a logistics thing. I mean, if the commission, a member of the public is not going to come in, generally speaking, is not going to come in for an application for up to, let's say 100 lots. But the commission might, if you're enacting new zones or you're, doing overlays and things like that. So, I mean, it's the logistics of it. Having Amanda send 100 certified letters is close to $1,000 worth of cost and a lot of time. So I think that's why the statute was changed to carve out that exception.
Probably.
Diane?
Okay.
I agree with wanting to have butters and people within a zone change or whatever notified. I think it's very important because people aren't always reading the newspaper to see that.
Not today.
Yeah, and also a little bit of a concern that I know in another application, 15 that were sent, a bunch came back. So I think that we also need to require that the addresses be accurate. And that doesn't seem to be the case in a lot of situations when these are sent out for anybody else, so it's kind of a key. Other than that, I think it's a good thing to not have to do the map survey.
So I'm in favor of the proposed change on the mapping requirements, and I'm also in favor, which is one step. I'm also in favor of the commission at a later date, taking on and adding the requirement to notify both the lots that are directly affected as well as the abutting ones.
Mr. Carter?
I'm in favor with respect to the map situation, the map change. As far as the notification, I'll wait and do research.
Yeah.
Because to be honest, there are costs. What happens if somebody doesn't get the notification? Does that put us in a situation if you try to do everything? Notify everybody and that doesn't happen. I don't know the implications of that, so I'm reserving my opinion.
Thank you. All right. Any other comments on the result, on the, text amendment? Last call for any public comment? Seeing none, I will close the public hearing for the text amendment. We'll move into the next item, which was Jam Real Estate LLC. That was withdrawn by the applicant, correct?
Yes.
For 16 Stony Hill. So we'll skip over that. We will continue now to the continued public hearing for 67 Greenwood and 69 Greenwood, which is also continued to December 9th by the applicant's request. So we'll move into the next.
On that, we request having a site walk for the new people on commission prior to the next meeting, otherwise we will not continue the next, after the.
If I remember correctly, that was discussed last meeting, and the new members were instructed to reach out to staff to coordinate that with the landowner, right?
Yeah, you're
And
right.
did
I'm
not
not-
happen.
I'm not
We
sure.
haven't seen anybody here.
They might have talked to David about it.
So.
I invited
you all-
both new commission members to be here later this evening, so we can ask them that.
So you all here didn't think it was important to have it?
No, we
I know,
did.
I brought it up and it was,
I think the majority of the
Nebulous.
commission didn't want
Yeah,
to do
no.
it.
It was something, if you wanted to, you
Yeah.
were available to
Correct.
reach out through staff
Correct.
on an individual basis to walk through.
And we've done that once already. We've got one commissioner who's gonna be over there this weekend visiting the site, and we reached out to the applicant with no issue.
So the applicant isn't going to be with them during the site?
No, I don't believe so.
Answered by,
so are you gonna let us know when that is so that anybody else can join in at that
Well,
time?
we don't want a quorum, because otherwise it turns
Right.
into a real meeting. So
Right.
if you would like to go individually, let us know and we'll reach out to the applicant's request.
All right, so that is continued to December 9th. So we'll move into the next continued public hearing, One Knollwood Drive LLC, 72 Reservoir Street. I am recused in the application, so Mike.
Alrighty, as Paul just had mentioned, we have, One Knollwood Drive LLC, 72 Reservoir Street, 830G site plan. I believe Mr. Marcus is here on behalf of the applicant. And I think we have Mr. Trinkus, the professional engineer as well. So the floor is yours.
Thank you. Record Neil Marcus, OPC, 58.
Apologies, Mr. Marcus. I want to seat, since I was recused, I'm going to seat Jeff DeRosa for Paul Shanley, please. Thank you.
Set together. And joining me this evening on Zoom is Steve Trinkus, if you meet him. And joining me tonight is Josh Federa, who's in the audience. He's a member of our firm who is joining us in our Danbury office, and he wants to see what we do here in the country. Bridgeport, the country ENZ commission. We wrote a letter on September 24th, which hopefully all of you've seen, outlining the amendments that we are seeking to address the reasons for denial were took place at your meeting on September 9th. The letter I wrote to Paul Shanley, the chair, and it states that under 8-30G, we had the opportunity to take advantage of 8-30B subsection F. It allows the applicant to submit proposed modifications to the plan responding to the objections articulated by the commission, which will be treated as an amendment to the original proposal. The amendments are filed in the time period that we're allowed to take appeal, and it defers the time for appeal until there's a decision on the amendments themselves. The amendments address only the issues that were the reasons for that. We're not going to go back this evening over the original plan. We're not going to discuss anything other than the 4 specific reasons for denial. Hopefully, if the public participates this evening, they'll be limited to addressing the reasons for denial, because it's not a retreat of the original application. Now, interestingly, before we get there, I was a little disappointed by the reasons for the denial coming basically on the heels of Judge O'Hanlon's 30-page memorandum of decision dealing with the requirements of section 8-30G. And I reread it today just to make sure that I think it was clear. And for those of you who haven't really studied what Judge O'Hanlon wrote in Saunders versus the Town of Bethel Zoning Commission, I'm going to draw your attention to a couple of key points before I start on the amendments. And one of them is that on page 17, the judge says, quote, the commission, actually it's the judge quoting a different decision that he used to support his decision, but the language that he used is as follows. The commission shall also have the burden to prove, based on the evidence in the record compiled before the commission, that the decision is necessary to protect substantial public interests in health, safety, or other matters which the commission may legally consider. And then they have to clearly have reasons for the need for affordable housing. So I'm going to go into the fact that I'm looking at the record that was reviewed on September 9th, and looking in that record to see what public health or safety or other matters that are legally before the commission were actually in the record to form a basis for the 4 grounds of denial. So that's the thrust of where we're going. Judge O'Hanlon went on to say that the record itself must establish more than a mere possibility of harm with substantial public interest. So not only do you have to identify the record what you think the harm is, but it's a possibility. The record, quoting the judge again, the record must contain evidence as to a quantifiable probability that the specific harm will result if the application is granted. Think about that when we come to snow storage for a few minutes on the site. The judge goes on to say that the lack of sufficient evidence in the record was the grounds for him to overturn the commission's decision in Saunders, and that I don't think that should be the case here. I don't think that we want to put this commission in position of asking Judge O'Hanlon to review the record here to determine whether or not it actually goes beyond the standard that he set forth in Saunders. His conclusion, obviously on page 28 of his brief, was for the reasons that the court elicited. The court finds that the commission had failed to demonstrate that there is any, much less sufficient evidence in the record that shows that denying the affordable housing development was necessary to protect the substantial interest in health and safety. So, having read that, I went back and looked at what I saw in the record, my notes of what was before you on September 9th, with respect to the 4 items. So the first item that seemed to be a reason for decision, I'm quoting your decision, it says the town attorney has advised that evidence does not support that the town owns the land outside of the paved travelable path of Knollwood Drive. Now, I challenge you to tell me what that has to do with health or safety. It has nothing to do with it. If, God forbid, and again, if you look at Steve Trinkus' letter who addresses this, if the O'Briens, who were the original subdividers of Knollwood, they were the family of the owners who failed to sign the deed that formally transferred the roadway to the town. If they come back now, 50 or 60 years later and say that we claim that that's our road and you have no right to travel on it, of course, you got a problem from everybody else who lives up on Knollwood Drive because everybody thinks it's a public road. But if that happens, there's no health or safety issue. There's a title dispute or potentially a claim for loss of money. They should say, well, the applicant here owes us money for trespassing or using our right of way. But there's no health, nor there's any safety issue involved. It's a title issue, which is completely irrelevant. And looking at what Judge O'Hanlon was looking at in Saunders, I don't want to give him an opportunity to say that the Planning and Zoning Commission of the Town of Bethel granted, it denied affordable housing because they were making a determination of title, which actually is way beyond your jurisdiction. It is an issue for the Superior Court. So keep that in mind, that our claim is that is not a valid grounds for denial. However, we actually go through the record of Knollwood Drive, and we go through the standards applied by the state of Connecticut, and we actually go and look at what Judge Fuller in his treatise on land use, and it's recognized in his treatise is authoritative on land use, what he says about the rights to use a roadway on a recorded subdivision map, even if there was a failure to formally sign a deed conveying, because the road was actually deeded by use in town for years. And the fact of the matter is that when my clients who own property directly across Knollwood Drive on the other side of the corner of Reservoir and Knollwood, when they were developing their properties there, which were not affordable housing, they went to the town to acquire the right of way that they needed for their project. And again, it wasn't the current town council, but it was the former town council who actually drafted the deed from the town to the Diorios to convey that title, which now the current town council says the town doesn't own. Now, granted, it was a quitclaim deed, it was not a warranty deed, but there's an indication that the belief was by the town and everybody who uses Knollwood, it's a public right of way under the control and the use of the town. So if you look at the authorities that we cited in our letter, the decision to deny affordable housing on that basis is out of line. And we think that that should be reversed. In fact, the ownership of Knollwood Drive is not relevant at all. The second issue that you quoted for or cited for a denial was sightline. And this, again, Steve Trinkus is here, he's gone back, and we have submitted a revised drawing was attached to this amendment. It shows a 290-foot sightline to the west, measured 10 feet from the traveled portion of the road. And that exceeds 10 times the speed limit on the road. And the commission, in your decision, and again, tell me if I'm wrong, where in the record is there anything that there's a problem with the roadway, the additional traffic from these 6 units will cause a public health or safety issue, here public safety? In the record, nothing is cited that says that the sightline has been a problem. I know that the consultants of the town has tried to establish a sightline based on the Connecticut DOT standards, but even the state DOT, when it came to the property at 9 Putnam Park Road, which is familiar with, that is the Tim Draper's application for affordable housing on Route 58. I was before this commission for a number of months. And even for the driveway there on Route 58, it's measured 10 feet back from the road. Now we're talking about Reservoir Street, which is not quite as busy a highway as Route 58. So to the extent that the state DOT allows a measurement to 10 feet in the travel portion of the road, we think that that should be allowed in the plans that are before you, in the amended plans that are before you, and that there's no hard and fast rule that uses 15 feet as the measurement for the sight line. It's a rule of thumb, but it does not set a standard that cannot be varied under the proper circumstances. The sight lines for the intersection of Millwood and Reservoir itself have been in existence for years. I mean, since the property was first developed as a subdivision 60 or more years ago. And if it works for all of the properties that have been permitted and given permits by the town, there's no reason to discriminate against the units that are proposed in this project. So it's our position that the commission hasn't maintained its burden of proof under 8-30G, showing how this specific sightline creates a public safety issue. And again, that burden is on the commission, as we know from Judge O'Hanlon's decision. Steve Trinkus, are you there on this issue?
Yes, I'm here, Neil.
Since you've done the sidelines, I'd like you to comment as well. We'll stop right there.
Yeah, Steve Trinkus, professional engineer, for the record. It's been standard practice since actually the late 70s when I worked for a surveyor in Georgetown when we did sight lines, that it was always 10 times the posted speed limit, especially on town roads. When you get on state roads, it's also 10 times the posted limit unless Connecticut DOT has actual speed data, what they call the 85th percentile. And as an example, when I did the Kevin Cleary's at 105 Milwaukee Avenue, the state had speed data on that section of 302. So the sight line was required to be a longer distance, which the state actually specifies for the 85th percentile speed. But historically on local roads, it has always been 10 times the posted speed limit taken from 10 foot back. If you think of sitting in a car, even in a big SUV, if the front of your car is at the white line of the travel lane that you're turning onto, you're really sitting about 6 foot back. You're not 8 foot, you're not 10 foot, you're not 15 foot back. So 10 foot is safe. That's what, as Neil pointed out, was allowed to be used on Tim Draper at 9 Putnam Park Road. I had a project in Bethlehem where they, 10 foot back, we would have had to really cut a slope back tremendously. And they permitted us to measure it from 8 foot back. So, you know, the state is flexible on this. It does not compromise safety. You know, we heard from neighbors during the first go round that people drive faster than the posted limit. That's an enforcement issue. That's not a sightline issue. And again, we're not creating a new road. We just have 3 driveways proposed off Millwood Drive. And so the existing condition is the existing condition, as Neil pointed out.
Thank you, Steve. And on the enforcement issue, again, in the Saunders case that I was referring to earlier, Judge O'Hanlon, on that specific issue. Now, granted, he wasn't talking about traffic enforcement, but he was talking about enforcing zoning regulations having to do with dust control on a neighboring property. But at the end of the day, if you read Judge O'Hanlon's decision, it's pretty clear that he takes enforcement out of the mix of a reason for denial. And quite honestly, there's a long tradition of that. The original housing court in the state of Connecticut that was appointed back when Public Act 89 the Public Act was approved in 89. It started 8-30G. In the case of Green versus the town of Richfield, the court found that the conditions of Ivy Hill Road, which were cited by all the neighbors as being dangerous and causing accidents, were conditions that were not in control of the applicant, not caused by the applicant. The applicant's property was vacant. But those conditions were required action by the town's board of selectmen. It's not a grounds for denial of the permit. So that goes back a long way. And then again, more recently in the Saunders case, that's where Joe Hanlon talks about the rights. So on the sightline issue, the other thing that's missing from the record is there's absolutely no indication of accidents being caused by sightline problems. If the record were going to try to support the issue of the sightline as a safety standard, the burden would be on the commission actually to put in the records from the Bethel Police Department showing how many accidents really occur at that intersection where one car hits another car because they didn't see each other. Now, accidents occur on Reservoir Street because cars may drive too fast, but that's a different issue. The issue we are dealing with is sightlines. How many people have gotten hit pulling out of Knollwood because they got hit by a car coming down Reservoir that they couldn't see? And the answer is, they're not many, because I took a look at the records and
Are there
there aren't
any?
many at all.
Are there any?
I didn't count them all, Jeff,
But
but
there's more than one. There's one or more.
I don't believe there is. I know in fact a couple of years, I didn't see it. But seriously, that was a quick look. But the burden was not on me. I was just curious. The burden is really unfortunately on you to say, here's why we said sightlines were a problem.
That's not what it said.
We had asked for that, and Steve Trinkus said he didn't get it from the police department, so we had asked for the records of the accidents. So it's not as though it's really our, because we'd asked for it from you.
I'm just quoting what Judge O'Hanlon said.
Okay, no, we don't
don't
like
make
you.
up these things.
Oh, we're just looking at facts from the.
Yeah.
But anyway, I'm just saying that it's not a correct reason to turn down this. Then we go to item number 3, and that's the building location. And the building location issue is really item number 2, a subfile of item number 2. The modified plan will show that the building closest to Reservoir Street does not impede the sideline. And that for the reasons that we said in the prior paragraph in our letter, for those reasons, applying the Connecticut DOT standard, which will allow a sideline to be measured from 10 feet away from the travel portion of the road, would allow that building. And again, on that one, since Steve is here, tell us what you've done about modifying that building location, Steve.
Well, Steve Trinkus, for the record, the building has not moved. The sight line at a point 10 foot back from the edge of the traveled lane on Reservoir, is right about just more or less at, the property line or a little bit over, but it does not interfere. The building does not interfere with the sight line at all. The sections that we drew are the existing topography and, showing, that there's no obstruction. So the building is not going to interfere with somebody pulling out of Knollwood and looking to the west, for a vehicle coming from that direction.
Amanda, do we have maps? I can see them.
You have the amendment ones we
Well,
submitted.
got.
Am I right? You said you meant, then you're just saying you didn't move anything, so
No, no.
the one doesn't change anything previously submitted?
The amended map would indicate that we have sufficient sidelines.
How would that amendment?
So then it's no amendment, though. You haven't changed anything. No line on that map has moved. That's what I'm trying to.
The line did move because originally I took it from the edge of the travel way. That's the edge of the pavement on Reservoir at the intersection of Knollwood. This measurement of 200 feet was taken from the edge of the travel lane, which is a couple feet to the north of the edge of the traveled road. So it may not look different, but it is slightly different.
The buildings didn't
What
move, the
does
sight
slightly-
lines.
What does slightly mean in measurements?
Steve, slightly, could you define it in measurements?
Is it 1 foot?
Well,
2 feet?
maybe the alignment of the line moved maybe a foot and a half from where it was originally, from 250 feet to 290 feet.
So you moved it a foot and a half and you got a
About a
40.
foot and a half it moved in front, along the frontage on Reservoir.
So you pushed
It's not a
the,
very big shift.
so you pushed the location of the measurement point towards the yellow line of Reservoir by a foot and a
Correct.
half.
Correct.
So you went in your favor a little bit and now you're getting another 40 feet of sight.
Correct.
From a foot and a half.
Yeah. Didn't take much.
Whatever you say.
So if we're ready to move on, the last issue is snow storage. Now, snow storage as a public health or safety issue is not something that we normally are concerned with. As a matter of fact, I have lived in this area for my entire life, in Danbury or Reading on either side of Bethel. And I've certainly driven through Bethel many, many times. I've driven through it in snowstorms and after snowstorms. And I've seen snow piled up on Greenwood Avenue, and actually I've seen snow piled up on downtown Main Street in Danbury, where you've had to remove it because it just interferes with parking and visibility on the main thoroughfare. But I've never seen or recall any case where a housing project, a condo project, a private home has had a health or safety issue because of snow and the inability to store it after it has snowed. I can't think of any instance where that would be health or safety. So at that point, I said to my civil engineer, Steve, snow, how much snow can we store as shown on the site? And how much snow can we expect on an average season in the town of Bethel? So Steve, why don't you take us through what you determined and how you did it?
So, I contacted Jack Drake, who's Connecticut Weather LLC. He's a meteorologist that routinely posts weather events on Facebook, and I asked him for snowfall records for the past 5 years in Bethel for what the average snowfall has been over the past 5 years, and it's been just over 25 inches has been our annual snow. And yes, in the past we have had larger storms back in 2010, 11, 12, and I think even 13. So a bit of a snow drought, but what I calculated was in the area between each of the three units, between the three driveways, and then to the area to the north of unit building number 1, we could store just over 20 inches of snow from our driveways without considering compaction of snow, which occurs when you plow it. It does not stay nice and fluffy. It actually condenses, quite a bit, and takes up less space. It doesn't include it assumes that all that snow is falling in one event, which has not been the case. And it also does not include the fact that, once you stockpile snow, it insulates the ground. And as it insulates the ground, the ground is much warmer than the outside air. Even during a 30-degree day, you will get, melting from the bottom of the snow pile. So we just simply looked at a worst case scenario. So I could take the snow from the 3 driveways and stockpile it between the driveway to 1 and 2, the driveway between 2 and 3, and to the north of building 1. In the event we have much more snow, the owner, TD and Sons, can bucket the snow down to the lawn area, which is on the west side of the 3 homes. We have a substantial lawn area there that it can simply be stockpiled, or it could be taken off site, which occurs in many places. If you look at, any of the shopping centers, in the Bethel Danbury area, when we have had snow years, they tended to have massive piles in their parking lot, which took up a lot of their available spaces. And they would have companies come in, take the snow and dump it somewhere else. They take it off site. So again, we can take 20 inches without any problem. And again, we're assuming it occurs all at once, which, based on the past few years, has not been the case.
So in terms of trying to relate this back to health or safety, I had trouble doing that. I mean, in reality, there are no health or safety issues about where you store the snow on the site. And there certainly is sufficient capacity on the site to store right now almost the entire average snowfall of the town of Bethel for each of the last 5 years. Because as Steve says, snow begins to melt, snow begins to evaporate, and that if you have a 10-foot snowfall 10-inch snowfall that you're going to store, it's not going to be 10 inches high for very many days. So we think that on that issue, there's absolutely nothing in the record that would substantiate any health or safety issues. Matter of fact, in the debate in all the discussion on snow storage, those words were never even mentioned. So on that issue, we think that the commission can concede that there is no health or safety issue and that there's sufficient capacity to either store snow on the site or the alternative to put it as a reasonable condition or approval that snowfalls in excess of a certain volume get stored off the site. That would be fine too. But there are ways to deal with this that don't overcome the ways to deal with it that don't mandate the denial of the affordable housing. So those are the 4 reasons for the denial. And quite honestly, we don't think any of them are substantiated by public health or safety issues in the record. Quite honestly, I don't want to take this up to the Superior Court to decide these issues, but I think the opportunity is for the commission to look at them. If you think that they need to be tweaked with conditions, you can do that too. But in reality, I don't think it's a title issue. I don't think that a speeding enforcement issue. I don't think the snow storage or the sight lines being artificially imposed on this site with standards from the state DOT are the grounds for sustaining the denial at this point. And it should be modified and reversed. The application should be approved with reasonable conditions that the commission may see fit. So we'll stand by for any questions if you have. Thank you. Thank you.
Alrighty, we have some members in the public that have signed up that would wish to address. I please remind you, as the council just said beforehand, that we do have to stick to the reasons for the denial as comments that you must make. Mr. Andrews, did you want to make a comment?
No, I agree on the procedure, and I'm happy to address a couple of the issues that Mr. Marcus mentioned. I can do that now or later.
I'd appreciate if the public got up and spoke, and then you can speak, and then the commission can add some comments and questions if that's okay.
That's perfectly fine.
Okay, Mr. Murphy, 74 Reservoir Street, please come up.
Scott Murphy, 74 Reservoir Street. I'm going to help Mr. Marcus a little bit here. The sight line for Knollwood, the O'Brien family had to come to my family to cut that hill the way it's cut right now, so they had a sight line. There was a stone wall approximately 4 feet high right there at the edge of the road. And Knollwood would not be there if my family said, nope, can't do it. But my family came to an agreement with the O'Briens. That hill was cut where it is for the sight line. The house that you're putting there, I understand what you did here. You moved 1.5 feet out to gain 40 feet. That's in your favor. The house is still in the same place. I will not be able to see getting out of my driveway. It is basically blocking that sight line that the O'Briens made when they put Mowood Drive in. And if I remember correctly from one of the last meetings, one of the things the board had asked was to eliminate one unit or shift the building back so that he could have his 6 units, which, while I find putting 6 units on that small piece of property a bit much, but that's the way the law is written. And unfortunately, I only speak common sense. I don't go into the terminology that the lawyers all use. So, but that's where I'm at with it. You know, I don't feel that moving the sight line out into the road further is going to address the issue of the house being in the way.
Thank you, Mr. Murphy. Nancy?
Oh, I had nothing to say
Oh.
about this.
Okay.
It's for later.
No problem. Lauren?
I'm Lauren Hussey, 73 Reservoir Street. I guess my first question is why you didn't show up for the meeting prior to this. There was a meeting scheduled and you didn't show up. So I'm just curious as to why, because now.
I thought the public hearing had been closed. Was the public hearing still open at that meeting?
Reopened.
It was real.
It was reopened last meeting.
So I was there because I was there. I'm not.
So I guess it's upsetting because this is such an important issue, but nobody bothered to show up for it. And I know this was not discussed tonight, but I do still have concerns about the blasting because I am directly across. So how does that impact?
Respectfully, we do have to keep it to the reasons for denial. We have to focus on those. We did discuss the blasting in the previous public hearings. They did have their expert come and discuss the blastings. Whether it was to your satisfaction or not, I can't speak to that, but unfortunately, we do have to stick with the reasons for denial.
Okay. Thank you.
Topics of conversation. Sorry about that.
If it's any comfort, there is a condition assessment, an existing condition assessment. If you're within X distance, with your permission, you can deny this. They would go in, they would survey your property so that after blasting, if there's any crack or any damage, any peeling, anything that can be attributed to the blasting, then it's their responsibility to mitigate that situation.
Okay, and they'll make us aware of that in writing or?
They will be notified.
Okay.
It's part of their condition of approval to notify the neighbors.
Okay.
Also, prior to blasting, there are whistles that go off to let you know in intervals, telling you how much time is left before the actual blasting. So there's a lot of this that has been covered that should be of some comfort to you.
Okay, thank you.
Thank you. Does anyone else here in the room wish to speak on behalf of this application? Not see anyone. Amanda, anyone online wish to speak?
Do not see any hands.
Okay. Attorney Andrews, if you have some comments that you would like to address, you had mentioned?
Yes, yes, Mr. Chair. On 2 of the issues, the first issue, the ownership or easement rights and access issue, that was the first reason. And then, the second one would be the sightline issue. On the first issue, I know that, the town attorney, Melanie O'Brien, has submitted a supplemental memorandum. I didn't know if, Mr. Marcus wanted to address anything that's going on there. Just a couple of things to be clear. Insofar as Mr. Marcus said, this was really not so much a public safety issue as a standing issue. In other words, I know that Mr. Marcus is saying, hey, look, the only reason you can deny an application is if it creates a substantial public safety issue that is not outweighed by the need for that outweighs the need for affordable housing that can't be addressed under reasonable conditions. Absolutely right. Those are the reasons. But the reality is that everyone has to show standing. In other words, Mr. Marcus can't have a client say, hey, I want to put a, affordable housing complex on the town park and there's no public safety issue, so you have to address it. He would not, even affordable housing applications have to show your standing. The issue here is it's a little more, it's nuanced, and he addressed part of that, is that as I read, Melanie O'Brien's comment is that, first of all, certainly there was a dedication, of the land for an easement granted for access and drainage. It was offered to the town, but there's no evidence, as what she points out, is that the town ever accepted that. The town, there was no formal acceptance of the street. I think you can certainly imply that the town accepted the traveled way because they use it and maintain it, and maybe some part of the abutting area that they mow and other things. So you can say applied acceptance. But there's a whole broad area. This is that goes up where they're proposing to do, grading and put in utilities and driveways and so forth. That the town they don't own it. And I think that her comment is she hasn't been able to find that the town even has an easement right on it. Because I agree, town ownership is irrelevant because most roads aren't owned. So that's her point, I think, and that's why. That I think she's saying, please address that. I think it can be addressed by a condition, but I don't want to make any what the basic claim is that you're not just connecting your house to the road, like a normal driveway, public road. You're going over this sort of territory that we're not sure who owns it. And I know Neil you said, hey, wait a minute, the town quit claimed its interest in the other side to a part of that. So maybe they own this one. Maybe they do. But I think more investigation needs to be done into that. And again, I think it can probably be addressed by a condition. But that's what the issue is, I think. It's more of a standing issue of your authority to do all this work you're proposing to do on land that the town doesn't own and doesn't seem to have an easement either. So that's what I think she's calling out. So that's issue number one. The sightline issue, I think that as I read it, the issue was, do you have to measure the sight line from 10 feet or 15 feet from the intersection? Because what I understood Mr. Ritchie to say is that's the AASHTO standard. You measured 15 feet from the intersection, and you guys are putting up a building that would probably block the sight line. That's what or measured. He didn't say that, just shows what it is. And I think what Mr. Trinkhouse has presented is we could show that we get 290 feet if it's 10 feet from the traveled right away. So I agree that's the issue. I think Mr. Trinkhouse is probably correct that the standard is 15 feet in the AASHTO manual. But whether 10 feet presents a public safety problem, that's a harder issue. And I agree that there have been certain examples that were cited where 10 feet has been allowed. So I think that's just my understanding of what the issue is. The issue is, and this is an existing condition. It's not, and it's only because you're erecting a building 3 feet from the property line that the sightline issue is being as an issue. So even if you found that there's no existing accidents at the intersection, that wouldn't necessarily prove anything because you're putting up a building there that may present a sight line. So the fact that there's nothing in the past with no building there, that doesn't necessarily show anything. So that's my understanding of those two issues. So if anyone has any questions for that, or I'm happy to speak with the commission or the applicant or anything else.
Thank you so very much. All right, we'll start online here with commission comments. Bob, Mr. Legard?
Well, I'm okay.
Okay, Kenny?
Yeah, I think the sightline issue is still a major issue.
The what?
We need
I'm
to
sorry,
seriously
Sightline issue.
Sightline.
one less unit would fix it.
Yeah, I mean, the sightline issue is certainly an issue. SLR has lots of comments about how it should be measured and the standards, the applicant's engineers measuring it in their favor. They pushed the point of measurement out into the road more. I'm not sure how that changed from their original assessment. They're also measuring not to the center line of the right in front of to your west, eastbound traffic. One of the comments by SLR that that end of that 290-foot line is more toward the yellow line, which should be in the center of the eastbound travel way. So they're clearly just putting things out here to help their case. I'm confused on why there was never an idea just to move the building back away from the road 5 feet. I mean, that would have, I think, solved everybody's. And we're looking at the contours on the map. Doesn't look like there's a big steep bank right there. So, you know, maybe the engineer can address that. Maybe there's some engineering issue about moving it south, the whole building complex. And as far as the snow removal, I would think that the snow removal or the lack thereof would fall under the purview of stormwater management practices, which are health and safety. So you can certainly deny an application with improper stormwater management practices. So the snow removal is certainly going to create water. I don't know how much water it creates. I don't know if the stormwater management on site would be able to gather it all. So I feel that is a health and safety issue.
Kitty?
I'm sorry, I think these two gentlemen have pretty much covered everything I was thinking of, and for Chuck's comments too, about the ownership and the title, these issues, I don't think have ever been addressed, and I think they have to be addressed before we move forward at all.
I agree with all of what you all have said. If you remember last winter, we had ice that the snow was not able to be removed from our homes. I'm concerned about, having it between those driveways. I mean, you're gonna scrape cars. That's not a safety issue for the people, but the cars are gonna get ruined, if you have an ice situation like we did. And the health department had mentioned about the snow being thrown from the road as it's being cleared. If it's that close to the house that's 3 feet from the property, from the line, and causing mold and everything else, and that was a problem with the stormwater and also Mr. Murphy's property and having all the snow back there. So I do think that in addition to what you said is a concern, and safety concern.
Roll.
So I'm perplexed as to why something as simple as moving the building, not changing the square foot of construction, but just moving it to solve this problem can't be done. I don't understand it. And for the record, I'm an architect with a structural engineering background. So this is not somebody who's not familiar with construction after doing it for better than 49 years. It would solve the problem. We're not asking you to change the footprint of the building. You could keep your square footage and demand the same rent and just look at, I'm not looking for answers. Okay, as far as the snow, and I certainly don't want to hear for the third time how snow melts, okay? We were told that the excess snow was going to be stockpiled in the back of the property where it would affect the neighbor through melt. And that's totally unacceptable. And it may not be a health and safety issue for the people that are living in this particular development, but it would be for the neighbor.
Can I add to?
So I just don't get the feeling that we're trying to reach some kind of a compromise here on these items. So that's it on my part.
Dan, Scarf?
I think the one question that will have to be the answer at some point is with respect to the title to the land, whether it's through condition or anything. It's still, there was a process used when they did something across the street. They went through a process. And there's got to be a process here to ensure legal title of land of some kind, according to the attorneys. I'm not an attorney, but the common sense says there has to be a process. You just can't grab the land.
Yeah, I agree with you 100%. The problem is the process, as I understand it, I didn't do it. But they went to the town and said, can you give us a deed? And now we can't do that because the town said, we should have given it to you back then. But I agree with you. Your theory is correct. I just got to figure out what the process is. I agree.
Anything else, Dan? I agree with all the commission comments as well. I would be okay with some sort of condition of approval for that first item, you know, as long as it's addressed prior to any development being done. I'm gonna go back to my closing comments on this, when we close the public hearing. I think it's where you're trying to put this in, with the site. There is more site there, but you're putting a giant retaining wall. Losing one unit and going from 5 to 6 to 5 solves your sightline issues. It spreads the buildings out a little bit, possibly gives you a little bit more room for snow stockpiling, which is another concern. It solves all the issues. You're entitled with the 2 lots technically here to 2 families. That's as of right. So you're getting one more with the 830G. I'd be okay with if the board was discussing some sort of approval of 5 units, condition of approval. That's my opinion. Something that I would entertain. Or if Mr. Trinkhouse has a reason why the whole thing can't be pushed down 5 feet down Knollwood Drive, love to hear that as well. Those are my comments.
Okay, well, my response is that this has been helpful. Chuck, as usual, has cited reason and authority in trying to deal with the title issue. And I think you're right, Chuck. We can come up with conditions, as Dan has also said, they can deal with that, whether we have to quiet the title, whether we have to have some sort of declaratory ruling that affects the title, that can be done. And I like to make some proposals on that and follow your lead and Dan's lead on that. The other issue that everybody's mentioned, I would like to have a few days to sit down with Steve and see if, can you say, get rid of a unit? Rule says you don't need to get rid of a unit, you just have to move the building. Somewhere between there, you know, and Mike, you say, make it 5 instead of 6. Somewhere in there, there's a compromise that I'm not sure what it is, but I gotta go back to Steve and our owners and see what we can move and if it can be moved or what we can delete. So
This is Steve. I can address this issue right now. I'm looking at the plan. We
I
can,
think that I prefer you probably don't. If you can, because I think, can we continue this?
Well, we would need your permission. Is that correct?
Yeah, so we're running into a timeline issue. The application was submitted on October 14th. The statute gives you 65 days. We scheduled to open the hearing 2 weeks ago. We had notified your office. I'm not sure what happened there. I apologize for that. So you would need to, by statute, you'd need to make a decision at your next meeting. So you could continue the hearing until then, and then render a decision that night as well. I mean, we can be prepared for that with conditions of approval. We can, you know, talk to
The decision doesn't need to be made tonight, but we are up against one more meeting.
Correct. Got it. Yes.
Steve, I would prefer that we actually draw up any changes at this point. I think it's more orderly for the commission and for us.
okay, okay, I'll be quiet.
Hard to imagine, but you're okay. I did that for the commission, not for you, Steve. But the same can be said about me most of the time. However, the comments are helpful. The issue of whether, I mean, we're thinking you pile the snow behind the buildings. It's not going to bother us. If you want us to give some thought about the drainage off of that snow pile, I want to look at that and see if that's something that actually merits
It drains right into its driveway.
to Murphy's Drive.
Yes.
If you're,
We can't use
Mr.
Mr. Murphy,
Murphy,
you can't see anyway.
please.
So we can't.
Mr. Marcus, can I help you?
Yes, sir.
Okay. Back when I wasn't even thought of and my family moved onto that property, they farmed it. Okay, so there's channels. If you go up there and I'll bring you onto my property and show you exactly how this works. I have a small retention pond at the end of my driveway. I have dry water beds that go out. That's how they watered the fields.
Yep.
Okay. And our property actually went to the brook where Tony Fernandez's house is now.
Yep.
Okay. So there's actually a twofold problem for the Fernandezes. The water coming off of my property ends up in their yard and in their basement. And we just found out that nobody's clearing the beaver dams out of the brook, so she had water from both ends coming into her basement. She had almost 3 feet of water in the basement. But all that water comes off of that hill, runs underground through my property, through dry water beds to water that big field next to my house. And by adding more snow to it would actually make it a swamp out in my yard, which tends to create a health issue with the mosquitoes.
Yeah, but he's proposing to put stormwater management practices. in.
Right, but I just wondered how that water works coming off of that hill might help him explain it to.
Or
to-
Jeff, we may have a condition of approval that we're gonna recommend that we do not store excess snow on the site that exceeds what's in the snow storage area that was originally designated. That could be the other thing. We won't pile it up there, but I want to take a look at that and be open and ask you guys to just be open-minded, Mr. Murphy as well. So no, your comments give me some reasonable optimism here that we can actually address it. So
Thank you.
Want to continue it, and then to your comment, if we get to the next meeting, if you need more time for a decision, we can address that.
Okay. All right, so this will be continued to our next regularly scheduled public hearing, December 9th, here in this room. Thank you.
And before I leave though, thank you for your time. Is it true you're not going to be there on December 9th?
That's fine.
Is this really?
First
your
time
last-
in 32 years.
You know, I just gotta take a moment for personal indulgence for you guys. I've been doing this for longer than 32 years, but I can hardly remember ever being at this commission without Kitty, either her presence physically or spiritually, because she may have been.
I may sit in the back of the room now.
You got one extraordinary lady.
Understood. Thank you, sir. I appreciate that. Thank you.
And you will be missed. Thank you.
Happy turkey.
Thank
And-
you.
and-
Good holiday.
As a member of the commission, thank you for your approach tonight. It's refreshing.
Do we clone you?
Old Tom. Thank you. guys.
All right.
Good holiday.
Bring back Paul. I was gonna go get water, so I can go get them. Let's move on to the business meeting.
Yes. Happy turkey.
Enjoy your grandchildren.
Did we turn that?
Bye-bye.
Why not?
Are we supposed to?
What's the first?
No, we're not on a break, Paul.
We're not on a break.
No.
Okay. We're just getting you. Sorry. You were on. I was on a break. Fall asleep. I almost thought about kicking my feet up. Run to the business meeting, Paul. Great. Paul, you gotta repeat yourself? Yes, I will unseat Jeff and reseat myself. We have a
Nope, I'm not.
Business meeting.
business meeting. Has everyone had a chance to look over the minutes for our last meeting? Any questions, comments, concerns?
I did review, I was not gonna attend the meeting, but I did review some.
Same with,
Video.
same with, myself. Excellent, thank you.
I wasn't here and I didn't review them. My computer's broken.
I'll make a motion to accept the minutes from November 10th.
Second.
All in favor?
Hi.
Right.
I abstain.
Stand. Any opposed? I think we're good. We have no invoices. That's correct, right, Amanda? I didn't see anything in my folder here. Okay, we are going to go to public input. I didn't have a sign up, but I see there's people here. So anyone online? Nothing. I'm going to assume Mr. Colts, you'd like to say,
Thank you.
floor is yours. Public comment.
Okay, again, Brad Colts, 1 Fairchild Drive. The governor has indicated he's going to sign HB 8002. I've read through the whole document a couple of times. I've spoken with much more knowledgeable people in this area than I am about some of the elements in it. And one of the concerns that I know we've been talking about for a few years. My love of the TOD. Thank you for that. Having a TOD apparently triggers a whole bunch of difficult things that make your role even less free to do what you want to do. The big one that I've zeroed in on is that apparently regular bus stops become satellite TODs with a quarter-mile radius. And if you've driven around town, you'll know that we have quite a few of those. The best estimate is that somewhere between 40 and 50% of the town would essentially fall into TODs of some kind. And if that's your wish, then, well, we'll have a conversation about that another night. But if it's not, I've been looking at I'll do this quickly. The public hearing back in September, two attorneys, including Mr. Olson, pointed out a number of legal flaws in how the map was being processed. I've done a review of the May 2025 amendments to the zoning regulations, and it certainly appears that those same flaws were there. And I've gone through all of the literature, the meeting minutes, and other elements from the 2017 adoption of TOD, and it appears that those flaws were there as well. There are also a few others that I've been digging through appear to have missed the attorney's notice, but apparently the EP needed to be notified. I don't think they mentioned that. There's also, I've been made aware, rules within the Connecticut statutes, specifically 98, which authorizes municipalities to do the stuff they're supposed to do. It would say that if you adopt an ordinance or regulation that's in violation of either a state statute or a local ordinance, that it can be determined to be null and void, which would essentially render the TOD null and void. Generally, that's done in court. The Bethel Preservation Society is prepared to go to court to try to get this done, but I'm going to be very candid. Less than 60 days to do it is going to be a hell of a challenge. If this commission were to officially recognize that those flaws existed in the 2017 adoption of the TOD, that would make the Preservation Society's efforts on this much easier. So I ask that you folks consider doing that. I know there's another meeting in December, but I also know that won't give us enough time to get in front of it. So I apologize for the urgency, but none of us could actually know what was in HB 8002 at your last meeting. So now that we see it and understand the impact of it, I wanted to raise that concern. And I'm happy to answer any questions you folks would have with me. I realize that's a little, but not certain.
Any other questions? Or see if there's any other public comment?
I have to go through the paperwork of what specifically you were talking about.
So I had provided.
Did you bring something with you? No?
Well, I provided you folks with recitation of those points. I believe it was the October 14th. I have a summary of some of it, but it's incomplete. And I've learned this evening that one of the things that the two attorneys had brought before you, which was the notification requirement, doesn't apply to you in terms of the property owners. It still does apply apparently to the adjoining communities and also apparently to the DVD. So I could share that with you, Kitty, but I think.
Hey, that is not enough time. That's not my last meeting, so.
But
that's about size of it.
Mr. Andrews is willing to render his opinion on that for you folks as some guidance. That might be helpful.
Thank you.
Great, thank you.
Is there anyone else? Any public comment?
Well, I thought I had signed up for that, but apparently I didn't.
You signed up for the text amendment, man.
Oh, no,
No, I
and
haven't.
72
There
reservoirs.
She is 72I4.
It's okay.
Oh, sorry about that.
You're allowed to come up and talk.
All right, well, I don't have much to say. That's the
It's
thing
giving
is,
you a little bit of a
he
hard
just, he just thinks a lot.
He said everything basically I wanted to say, so what I wanted to say was I'm requesting that you recognize that the TOD was improperly adopted, apparently in 2017, and is therefore invalid, I guess. So if I understand that correctly, the new state bill is going to give the state more power to do what we really don't want it to do anyway. And so I think it behooves you guys to make a statement so that we know that you agree it's invalid and you perhaps can rescind it. And all the reasons that you had were these right there. I printed them out and I didn't know you didn't have them. So anyway, that's really all I had to say. I agree with everything you said and I wrote you guys a letter too.
Nancy, I think what Kitty, if I'm correct, was looking for was the actual statute elements.
Oh,
And I
okay.
didn't. I
That's
didn't-
okay, thank you.
Thank you, Nancy.
Thank you.
Any other public comment?
Thank you.
Before I turn it over to Beth, is anyone online?
What's it, Chuck, in it?
Are we gonna have to check?
Who's gonna comment on what
I
we're
think,
talking
I
about?
think Beth is free of the public.
Yeah, no, Beth's here as a member of the public. All right. Beth Cavagna,
Are you going into executive session after I speak?
yes.
Okay, then I will speak. I'm here for several reasons. And all of them good. Okay, first of all, I want to say thank you to Diane for your service on the board and have enjoyed the time with your little grand one. Doug isn't here, but he doesn't count anyways because he's just going to ZBA, so he'll be right around the corner. But there's two people I really want to say thank you to. One is you. Paul, I just want to say that, I had to write it down. I don't want to get emotional.
Okay.
Okay? Yeah, the flowers, I was gonna give him flowers, but then I
It's
said,
really
no.
gonna be nice.
I just want to thank you, seriously though, for striving to bring everybody on the board together, striving to try to communicate with the applicants, and striving to communicate with the general public and create an atmosphere of good communication between all of us. It's been a real struggle for you. I say a struggle because you walked into a pot of boiling water. And for 4 years, you've done your best, and I thank you. You've made some great changes with the commission. And I think that tonight will be the last night that you will need your medicine before you go to bed. So I just wanted to give you your medicine.
Thank you. Thank you very
You can
much.
open it.
Thank
You
you.
can't drink it.
Okay.
Is it good?
Oh,
Share it.
That'll work.
That'll work.
It'll work. I knew it would.
Yeah. Thank you.
Okay, now this is the hard part. Miss Kitty, 32 years on the commission. I started, I know, oh, we have an attorney on, I'm sorry. I started 25 years ago with her. And Dennis Reardon and Bob Legnard. And there is no one on this earth that can be compared to Dennis Reardon except for these two as far as honesty and integrity. And I go back to when Dennis was the chair. And we were in a very ugly legal case.
Oh, yes, I
And
remember.
because of his honesty and integrity, he stepped aside and let you all make a decision that was in the best interest of the town without telling you some serious personal issues that were going on in his life. And we all learned from that, and that's one of the main reasons I stayed here. But I will tell you that if it wasn't for you two, there are many times that I would have stepped away. But the two of you, and especially you, Kitty, I think Amanda can attest to it, and I'm not saying anything negative about all you guys. You're all great. But she would step in, she would call in the morning, she would stop down Tuesday mornings, every Tuesday morning, she heard clumping down the hall to come and review the files. The day after a meeting, the phone call, are you okay? Is everything okay? Bob is notorious for doing that still to this day. But you cared about your staff tremendously. And we've developed friendships over the years. And I'm here to say thank you on behalf of David and myself and Amanda. And it's probably the first time in my life that I've been really nice to somebody. So of course, I have to give you flowers. Okay. And of course, I had to go shopping at the Bethel Gift Cottage. And of course, Joan, when I told her what I was doing, Joan sent truffles. So
Charlie's not here to eat them.
I know, I figured, but hey,
Excited for myself.
I don't mess with Joan. When Joan says, give these to her, I just want to say thank you very much and I love you.
Hi.
All right? And
I
I'm
love
sorry David couldn't be here tonight too,
I love you.
but it's okay.
Thank you.
All right? Thank
you
you guys.
for everything.
Thank you all for letting me do this. I really
Oh,
appreciate it.
Of course.
Okay?
Thank you, Beth.
All right, take care.
Thank you.
Good night.
Okay, any other public input? Online?
Michael,
Yes.
I have a few words to say about, our department members.
No.
And I would like to thank Paul again. I know Paul since he was a little kid pumping gas at Shannon's gas station. He worked on my cars. He turned out to be a fine young gentleman who his town and his family can be proud of. And now he's raising his own family in Bethel. He's a kid who cares about Bethel. He worked hard for 4 years. He put his family first, and nobody could fault him for that. He wants his family to spend time with him. As his, he had spent with time with him. And Kitty, same thing. People who think we do this for, we get rich doing this. You know, it's crazy. I mean, the time away from your family, they're the ones that are being commended. The time your family misses out, where they don't get to see you at night after a meeting, because the meeting goes from 10:30, 11 o'clock at night. And so, Diane, same thing. You're really commended for your time of service.
Yep.
You did it honestly. You cared about the town. You cared about the developers. You cared mostly that we get it right. And that's what we're here for. Get it right.
Thank you, Bob. Thank you, Bob.
Thank you, Bob.
All right. Well, before we get too off track and off our agenda, there's no other public input. I don't see anyone inside. Nothing. No one online. We are going to move into an executive session we're having tonight. I'm going to invite in the newly elected members of the board. They haven't been sworn in yet. We have Danny Sorrentz with us, and online we have Molly Dories. We're also going to invite Chuck Andrews in, and all of our attending staff this evening. To our the first selectman. I don't know if you need an official invite as a member of the board. So that being said, I ask the participating public to clear the room, close the door behind you, please.
Yeah, Mr. Chairman, just before we go into executive session, just because it's not on the agenda, I just want to make a note, put it on the record that the executive session pertains to the matter of vessel technology versus the planning and zoning commission of town of Bethel. Yes.
So can we do any other motions during executive sessions or we gotta come back out?
No motions during executive
We
session.
still have two items on the agenda after the executive session. We have the planner's report and commission comments.
Will someone let us know when we can come back?
Yes.
Yes, they will.
Come open the door. One of us will open the door.
We'll be meeting about-
Thank you.
Thank you.
I'll make a motion to go into the executive session with all the invitees that I listed.
Second.
All in favor?
Aye.
Any opposed? Abstentions? Amanda, can you kill the recording and make sure there's no one in here that shouldn't be? Let everyone back
Recording
in.
has started.
All right, just wait for them to come in.
Oh, you guys are welcome back.
Oh, to let them in. I forgot they were still out there.
I might not even stay for it. Yeah, right. It won't be solved.
I'd rather be out golfing.
Fine.
Happy turkey, Dan.
Yeah, happy Thanksgiving.
Happy Thanksgiving, Dan.
All right.
Yeah.
In the executive session, no decisions are made, no votes are taken.
It's nice that you guys say that because before I don't think that was ever said.
No, it's been
It's
said
in the
that
minutes.
before.
I put it in
Definitely
the
been said
minutes.
before, but yes. No votes were taken, no decisions were made. All right, we will move on to the planner's report.
Minor report, we're continuing to work on that moratorium. We are trying as best we can to collect the compliance certificates. That's kind of the big missing component at this point. And it's evolution of the process. So we've got letters out to the owners. We're asking for those things to come back to us. The second letter that goes out when we don't get response, we've gotten a couple of responses, so that's good. We have a lot more to go. I just learned last week that even the projects that are overseen by the town's affordable housing administrator, we're going to have to certify those. We're going to have to collect those certifications, not the affordable housing administrator. So we're starting up that process. And I'm saying all this because Rule asked me the question earlier, and he's got an email to this effect. So we'll just tell you all. So we're starting that process. So letter number 1 is basically, you need to do this. It's in your affordable housing plan. You said you were going to do it. You haven't been doing it, and now you have to. Letter number 2 that will go out when we don't get responses is, you have to do this. And if you don't, it's a zoning violation because that's the only way we can pursue it. And then the third letter that goes out, if we get there, because we still don't have responses, is here's a notice of violation. So that's where we are. That's the process. And we're working it.
Does a notice of violation have teeth?
At the moment,
It should be money.
well, so there's an I believe, and Dan just left the room, but the state statutes give us the ability, not us, the board of selectmen, the ability to enact an ordinance where you can fine for those notices of violation. I do not believe the town does not have that ordinance on the books at the moment, but it is in the queue as part of the ordinance update that they're working on. And it's changed recently, so forgive me, I don't remember the number, but I think it's up to $150 per day per violation. And the way I would write those notices of violation up, if it were me, if we get to that point, would be to say that each unit that we're not, that we don't have on the record. So if it's a 10-unit structure and 5 of them are affordable, each affordable unit is a violation. So that's 5 times 150 per day, as long as that violation. So that's our key. But we don't have that yet, so that's the cap.
Would that ordinance and violations be applicable to all zoning in
Yes.
the town, not just
All
the-
zoning violations, yes.
So like if your neighbor's building a shed and didn't get a permit,
That's right. $150.
where's that guy?
Wow.
Per shed.
See what
Per
my
shed.
dad's doing.
Per day.
Per day.
So it's the statute that allows the town to do that is 8-12.
I got a question for you. If we're close now, and we applied for a moratorium before January 1st, it falls under the current rules. If we don't apply now and we apply after January 1st and that thing gets signed by the governor, there's a whole new set of rules for moratorium in there. And it may be extremely difficult for us to ever get a moratorium. If I'm reading it correctly.
Yeah, I have to go back and look at the effective date of that section. The Public Act has a whole bunch of different effective dates for.
Right, but it's a severe decision for us if we don't apply before January 1st. And if it's as severe as I think it is, we may never get a moratorium if those rules, if I'm interpreting them correctly, we'll never get it.
Yeah, I'm not going to answer that at the moment. I've got to go back and look at it, to be honest with you, Ken. It's been a minute, and I mean, we can ask Chuck. I don't know if he's even fully aware of what's in there right now. I don't know if he's still listening or not.
So I'm
there's a
gonna
couple
say,
things, but I can report back.
We gotta be really careful about this.
I agree.
Because, let's say Christmas is the last business day right before Christmas, before it gets sent up to the state. Even if we have to amend it a little bit afterwards, we're still in the old rules. If the new rules come into effect, we may not get the moratorium ever.
It's on my radar to check into. I just don't have an answer.
Okay, because,
Yeah.
I'm aware of it, and
Here's the challenge. We have 19 properties. 2 of them have complete paperwork.
Oh, so we don't even have, that was my
It's
question.
the certifications. It's
Right.
the compliance certification. That's what we're missing.
So we only have the numbers, the Huey points only count once you have the certification.
Correct.
So you can have them, you can have the Huey points in theory, but if you don't have the backup for it, throw them out the window.
Correct. They're in violation,
Right, but it doesn't,
but
the
the
state,
state,
the state's not gonna say, you have them, here's your moratorium, go figure out the paperwork. We gotta get this paperwork correct
Correct.
the first time.
that's right.
I haven't had a migraine in like 6 months.
CPA. So,
I'm not going to ZBA wetlands.
Oh, you're in wetlands? Oh, nice.
so the number that we have actually certified is
Terribly low.
at or below what we need?
Well, it's, I mean, the number that we have, well, it's two properties, the point.
I don't mean the properties, I meant the total number.
Yeah,
How many-
it's not 159.
How many Huey points are coming from those 2 properties? Can you have that information handy? I think that's what he's asking.
I mean, if we're clearly short, I can understand it, but.
I'm pretty comfortable in the fact that we probably have the compliance. It's, we need to get the paperwork. So that's where we're at.
I know Beth was trying to submit this stuff back in like May or something, and
There was,
these compliance things are kind of new to us, or?
yeah, there were compliance certificates, I think, that were collected for 2023 for some of the properties. But it's, you know, we never actually got the application in with the state. We've
Right.
now gone through 24 and now we're about to get through 25. So what we're doing is we're trying to get the 24 compliance certificates before the end of the year and then force the issue as of January for 2025, right? So you're certifying the prior year each year. The affordable, the plans all say on or about January 1st. Some of them are a little bit more specific than that. So they say by January 15th, the developers have to submit this information to the town. They're supposed to be doing it anyway. It just hasn't happened.
And no one's been following up on it.
Yes. So we've set up that process now. So we're sort of starting fresh with this stuff in a lot of ways.
So there's no recourse from the state for these people not handing these things.
You know, it's a zoning violation, so it's put back on us to enforce it as a zoning violation.
But you'll let us know by email if, you know,
Doesn't sound
if
like
that,
I'm gonna get
if that rule in January
Yeah.
comes into effect and
Yes.
it erases us.
Yes.
So Ken,
Yeah,
a
I'm
number
good
of
with it.
these locations, we haven't sent them a letter requesting a compliance certificate since 2019, 2020, 2021, 2022.
Have we now? Is that-
That's the problem.
Yeah, letters are,
And
the ones that I just found out that we have to do are going out this week, I think, and I got some of them today to go out, so. The rest of them will go out by the time she goes home for Thanksgiving. So, yeah, I mean, we're playing catch up. I'm not gonna lie to you, but
Yeah.
it is what it is. I mean, it's a process. As I said to Sproul in the email, it's a complicated and cumbersome process. It's that way for a reason. There's a learning curve with everything here, staff, town attorney, you know, you name it. We've all had to go through the learning process.
If a developer had an outstanding violation, would we be able to accept a new application for them for an 830G project?
It's a good question, and I've had that asked before.
It's a really good question.
It is a good question, and you know, I don't know. There's nothing written, certainly there's nothing written that says you have the ability to reject an application. It would be up to case law, and that's, I just don't know.
Can we put that in our books?
Well, we have to get the ordinance to get the violations
No.
first.
So can we make that part of Bethel rule?
No, because you're governed by 830G.
Yeah, but if you think about it, the developer is getting through the loophole
Oh, I know.
by doing
Oh, yeah.
830G,
I know
and
where you're coming
then we're not even getting credit for it.
I know where you're coming from.
Well, the last year and a half, that's all we've had is 830G.
So what we need to do is push the issue with the Board of Selectmen.
To get the
To get
ordinance,
the
to get the
ordinance
violations.
Yes, so anytime you talk to those folks that sit on that board, get that ordinance adopted.
Yeah.
Because it's gonna help you anyway with all.
Oh, the whole town,
Yeah.
of course.
Yeah, every town I've been in, I've always pushed for that.
Has it been written yet?
I couldn't tell you. I think there's a draft, yeah, I think there
Who's
is.
writing it?
I suspect Melody's working on it.
All right, is that it for your planners report? We
Yeah,
kinda went off the rails
the
a little
only
bit.
other thing I will say is that happy Thanksgiving to you all. Paul, Kitty, Diane will miss you. Thank you, Paul, especially to you. I have not been here very long, but I really appreciate the relationship that we've been able to develop, and it's been great working with you. So I really appreciate it.
Likewise. All right, we'll move down to commission comments. We'll start with Mr. Legnard.
I made most of my comments before, but I do thank every one of you for your hard work. I know it's not easy. I've been there a while too, like Kitty. You're right if you do, you're right if you don't. As long as you're doing it good for Bethel, that's all we can ask.
Jeremy,
Yes, sir.
can I make a motion related to the TOD?
You would need to make a motion to amend the agenda first to put a discussion topic on there, and then you can make a motion to talk about the TOD.
Okay, making a motion to make a motion.
So you're making a motion to amend the
Amend the
agenda to
agenda.
add a discussion topic of what, TOD?
TOD, yeah. That's my motion.
Do I hear a
Second,
Thank you. All right.
All in favor?
Right.
Any opposed? Any
This
abstentions?
is quick.
Motion passes. All right.
So concerning the possibility that the TOD is in violation, I make a motion that this commission acknowledge on the record that the TOD created in 2017 did not comply with local law and state law. So I'd like to make that motion and.
Can you read that? Can you say that one more time?
Sure. I make a motion that this commission acknowledge on the record that the TOD created in 2017 did not comply with local and state law and it's in violation.
We have a second? We have a second?
Do I have a second?
No?
Oh, then it just fails.
Yeah, motion dies.
Yeah.
The motion dies.
Yeah.
I'll ask one more time. Do we have a second for the motion?
A chance to get rid of it.
We do
I
not
think
have
you
a
need
motion.
more explanation, Ken.
This
We
is
do
just
have
the
to-
starting process. It has to
Yeah.
go to, we have to have a public hearing.
I think when you start again next year, I think you have to get into it and find out what the problem was and where, what, and how to fix it.
Right.
And you can't do it as
This is just a start. This doesn't do anything other than get the start back.
So if I can, I get it. I know where you're going. I know there's a lot of heartache over the TOD. That's fine. And I think, we've talked about amending the boundaries, and I think it's a valid conversation to have. I think a motion such as that does nothing but add to some confusion.
Yeah.
Because if we put a motion like that on the record, we're gonna have some folks say, well, you just said that it's illegal, so it doesn't exist, right? But that's not the case. Regardless of what happened back in 2017, doesn't really matter. The appeal period ran out 15 days after the legal notice was issued. And so there's case law on this. I think I sent it in an email earlier today. The appeal period's over, the appeal period's over. Now, the commission has a process that you can follow. It's set forth in 8.3. You can make a motion in the future to go back and submit an application to repeal it. That's all well and good. You can do that. But I think a motion to put on the record that an action that was taken 8 years ago, probably with a commission that is fairly different than what this is, just confuses I think it confuses the public, and I think it might even confuse incoming commission members. So that's my take on it. You don't have to listen to me, but that's what I'm going to say about that. I've talked with Chuck about this. And so I'll leave it at
Make a comment, because we are talking to the TOD. Brad has sent me an email today, yesterday. I had taken his email, I had forwarded it to Jeremy, I forwarded it to Dan Carter, I forwarded it to Chuck. And I think the words I used with Chuck, I said, along the lines where, Chuck, look into this. If this has any teeth, I want to move on this very quickly. Chuck sent back a very detailed email, which then I forwarded to Jeremy and asked Jeremy to forward to the commission. You guys should have all got it today.
Yeah.
And Chuck addressed each issue. Now, I'm not saying there's a couple of them, there's a couple of them that, are a gray area, let's say. I am not prepared to second that motion as, I wasn't in town. I didn't live, that was actually, there was a 4-year block that I didn't live in Bethel. It was that. I know. Oh, sorry. No,
College.
no, it wasn't even college. It was, no. But anyways, I didn't live in town during the time when the TOD was adopted. I've never gone back and watched any of the videos, watched the minutes. So I wouldn't make a second because I don't know 100%. I wasn't there. Secondly, I understand what Mr. Colts was saying earlier with his comments, and even Ms. Sudik was saying, and I get where they're coming from, right? But there is a process, and we already have a live motion on the floor to amend the TOD's boundaries. That has not gone away. We suspended it. We pulled our application to fix the map issue, which we closed the public hearing on tonight, and I assume will be on the next work session. We all gave a positive report, and that way I anticipate that to pass. Then we can refile for the TOD redraw, if you will. That being said, if a motion was put forward to just eliminate the TOD, that would be something completely different than acknowledging something that happened in the past where I personally cannot say in good faith, I wasn't there.
I get it.
You know, if you want to ask me about the schmood, I was there. I voted on it. I voted to get rid of it. You know, I was integral.
You and me both.
But TOD, I wasn't. And as far as TOD goes, I don't know what change in May of 2025 you were referencing.
There was 2 sentences in the reg that got changed.
But not having to do with the TOD. There was the dumpsters that you changed and the beer gardens, I think.
Okay.
Yes.
Okay. Those, I think the only TOD changes we made is we reduced density and overall height last year or the year before from the original. So I think, me personally, I think TOD steps have been taken already to reel in TOD. Whatever this monster of a bill is that's being passed and rushed through in the middle of the night up in Hartford, we don't know.
Watch it.
That's all I'm gonna say about it. Does
Jeremy?
anybody else have anything to say?
Yeah, just.
TOD
We
wise?
talked about this TOD thing, over a year ago, and
It comes up that month.
I know, but we joked that, where I'm going with this, this topic was rebranding of it. Like, is the words transit-oriented development what triggers potentially what's in this bill from the governor that he might sign? If it's rebranded, then there's a lot of things that have to happen on Bethel overlay zone type of a situation.
Economic development.
Yes.
Economic development, multifamily, mixed use overlay zone, instead of a transit oriented development that, again, I get comes with grants and whatnot we can get from the state, and if you have a transit oriented development, but in exchange we could potentially be handing the keys over to Hartford. It's not as easy as just rebranding it.
No, but what I would say is that the bill is full of carrots that have to do with TOD. So if you adopt a TOD that fits in their model of a TOD, then you can get a whole bunch of money out of it. If your TOD doesn't fit their model, then you can't extract that money from those grants. So it's not that if you have a TOD, it has to be this. It's if you have a TOD and it meets this, you get priority of funding for all these things. So it's not quite like, oh, you have a TOD, now we're telling you what to do with it. That's not quite how the bill works. This bill, the original 5002 had a whole lot of sticks, and it had a number of sticks. This latest thing has a lot of carrots and a few sticks. one of the sticks that, and we need to talk about this come January because this piece of it goes into effect in July. One of the things that it does is takes away minimum parking on housing developments under 16 units.
Right.
However, there's a carve out that if you create a zone, and I forget what it's called, but it's like a traffic mitigation zone, basically. If you create that, it can't be any larger than 8% of the town, right? So you take the square mileage of the town, whatever 8% is, it can't be any larger than that. You can regulate your parking, and you have to cite certain things, and there's a process to do it, but you can do it. One of the things that you might want to consider is taking your existing TOD and saying, yes, within this area, I'm sure it's less than 8% of the square mileage. Within this area, we're going to call this one of these traffic mitigation zones, and we're going to have parking standards. So there is a carve out there. There's a way around it. So we need to get into that bill, which I fully intend to do come January, and once we get through some of this other stuff that we've got. And that's one of the things that you need to consider. I had Amanda send you a slideshow, I think it was last week or the week before, that Westcott put out, kind of saying, here's the things that are on fire that we need to deal with before July. And I think you'd agree that it's not really that many. Parking is probably the biggest issue there. Your TOD actually is somewhat convenient in that it brings you in line with some of the stuff that, is required in that bill. Some of the commercial to residential conversion site plan stuff as opposed to special permit. You're already doing it. So you're already compliant with the law in some way. Again, you can adjust those boundaries. We can talk about that. But I think you're in a pretty good spot right now with regard to that legislation.
Okay. Anyone else have anything TOD related?
Any other commission comments?
No, well, we're in the,
No, we're still on
we're still in the TOD
No, look
discussion.
at that. We're still on that. I forgot we made another agenda. All right, thanks, Ken.
Okay. Okay, somebody seconded the motion.
Kitty did.
Okay.
All right.
Jeff, you got anything? I'll move out of, if no one has anything for TOD discussion, we'll move back into commission comments. Jeff?
Yes, a couple things. Last meeting, we talked about, there was a mention of historic preservation, historic districts and how we don't have one, and we've tried, and
Mucho grande difficult.
so, maybe after we get through all this other stuff, we get through something because I think that's the common goal of everybody in Bethel, is that we want to keep Bethel quaint. You want to keep the historic homes like they are. So, people, if we're in a historic district and you could get funding to work on your home, then maybe people are more likely to keep their house instead of tearing it down. So, I think that's something in the long run for, we put on the agenda. Yeah. I didn't go through
Work
it.
at it. Okay, if you have the time. Yeah.
I know you need a commission. You would need a commission.
Yeah.
The board, the selectmen would have to
Yeah.
appoint a historic commission, and, it's a
Exactly.
big ordeal. So, something maybe we put on the back
You
burner
get
for now.
you'd get people to jump on that.
Yeah.
Maybe you would.
How long ago did you guys try?
Oh, gosh. Harris was our chairman, so it's quite a while ago.
Okay.
But she's chairman of the, she was chairman, president of the Historical Society. So
Oh.
you want to talk to her,
Okay.
that'd be a good idea.
Thank you, guys. They're all leaving. I know you put in a lot of work. Diane, I know you do your homework all the time. Paul, having young kids and doing this job, I can't imagine how you do that. So, Kitty, very impressive. 32
Oh,
years.
darling, thank you.
Absolutely
Yeah,
impressive.
loved every
So,
minute of it.
we're lucky to have you and all
Thank
your
you, dear.
knowledge. So we hope to see you guys sitting at least on the other side of
Oh, you're going to.
for some meetings. Thank you.
Yeah, same thing. Thank you, the three of you guys. Kitty, it's been fun working on this side of the table, and it's been fun sitting on the other side presenting to you over the years.
That's
And
right,
I've
you've done
always-
that too.
I've done both sides, so I appreciate that.
That's right.
Thank you.
Thank you.
Kitty?
I loved it, every minute of it. I wouldn't change it for anything in the world. And I wish you all the best, because this is something, somebody said to me, well, you're just doing whatever. I said, no, I said, I'm doing what I was elected to do. And that is to work for the people of this town who gave me such a wonderful life. And I thank them, and I thank them every day of my life. And I thank all of you, and I wish you tremendous success. And I know you're gonna have it, so you'll all be good.
Diane?
I appreciated representing the town and really respect all of you. I think you do great work and wish you the best. So I may be on the other side sometime. I was before I was on here,
Oh,
so.
yeah.
Alright. Scroll.
Again, thank you to the three of you. I know this is time consuming, you have family and we all have our own lives. But thank you. Well done.
Excellent. Well, before I say my comments, I have some work to do. It was brought up about the notification, and that was a different section. I think we were all talking about that. Is it appropriate for me to make a motion to propose that change?
Please. Yeah, I would make a motion to amend the agenda, put that on there as a topic.
Okay.
You always have to do that.
I'm making a motion to amend the agenda to add a text amendment for notification changes.
Second.
All in favor?
Aye.
Any opposed? Any abstentions? Motion passes. Jeremy, what was the exact, you listed it before, what
Yeah,
section? in our-
810G. There may be
8-10.
another one that I have to.
G, and that is to, require public notice for
Is that a change?
anyone inside or abutting a zone that is, proposed, initiated by the commission. So I'll make that motion to change, section 8-10-G to require notification for anyone inside or abutting a zone change that is initiated by the commission.
So that's a motion?
That's a motion.
Second.
All in favor?
Aye.
Any opposed? Any abstentions? Motion passes. So can you please schedule that for a public hearing?
Well, we need to get the application in
Yeah,
and schedule.
you
the
got
hearing.
the-
I will get you,
Get the ball rolling.
I will get you some proposed language for your next meeting on the night.
Excellent.
Thank you.
Excellent. So after that, we'll move back to commission comments. Thank you, guys. Thank you, Kitty. You're decades of work on this commission. It's not taken lightly.
And getting elected every time.
Yeah,
Yeah.
yeah.
He talked about that.
And, I think that's it. So
Okay, motion to adjourn?
what's that?
Yeah,
Yeah, would you like to make a motion?
I'd love to make a motion to adjourn.
And I'll second that.
And
All in
happy
favor?
turkey.
Aye. All right. Have a good night, everyone.
Okay. Okay.